Hello everyone, welcome and thank you for joining us for today's webinar on employee monitoring. This is part of a webinar series by Fieldfisher's Privacy, Security and Information Law Group. My name is David Lorimer and I am a director in Fieldfisher. Today I'm joined by my colleague Rachel Rigg. We both specialise in matters which involve the overlap of employment and data protection law, including today's topic. This session, along with the others in our Get Data Protection Fit series, is available on our website and YouTube channel. Rachel is now going to take us through where we are in the series and how we got here. She'll then run through the agenda for today, the common types of employee monitoring, and the legal framework.
Thanks, David. So this webinar today is part of our Get Data Protection Fit programme for lawyers and privacy professionals, covering the fundamentals of data protection law. Click the link to be taken to the Fieldfisher YouTube channel where you can find the other webinars in the series. Across May and June, Module 1 covered the fundamentals of data protection law, including topics such as the key concepts for data protection, principles and grounds for processing personal data and data subject rights. These are now available to revisit on our YouTube channel. Across June and July, Module 2A of the series looked at putting data protection into practice, including controllers and processors, and implementing data processing agreements. And now you're joining us partway through Module 2B of putting data protection into practice. So far in July, we've covered DSARs, what to do when you receive one, and DPIAs, how to create, when to use and review them. And now we're covering employee monitoring, but later on in the series, we'll be looking at data protection due diligence, DPOs, and handling regulatory investigations and other practical tips. So by the end of this session, we'll have touched on the different types of employee monitoring, understanding the regulatory and legal framework, and how to apply the most important principles when carrying out employee monitoring. This webinar is designed to cover these topics at a high level and will not go into the other types of employee-related data processing, such as pre-employment background checks. So, as we've promised, in learning about employee monitoring, we're going to cover the types of employee monitoring, the regulatory and legal framework, the key principles, including TRAP, which you'll learn more about later, and some practical tips and takeaways for you to be mindful of in future. Employers can monitor employees in many different ways, with some more invasive than others. Monitoring should only be carried out to target specific tasks, which is called targeted monitoring. Targeted monitoring should avoid places or parts of platforms where individuals have a high expectation of privacy. For example, it should not monitor personal or private files or messages, and should not monitor continuously where more limited sampling methods would be sufficient. Examples include internet use, which could be monitoring the sites that employees access, or a blanket restriction on certain content. Telephone and email use, which might be taking recording samples of phone calls, measuring the traffic of calls and emails to measure productivity, and monitoring the content of emails and calls. Computer programs can be used to flag danger words or restrict access to certain destination addresses. Employees can also be monitored through access logs for swipe cards throughout the buildings, or CCTV surveillance, which is a much more invasive way of monitoring what employees are doing, who has access to certain different areas of the office building, etc. Employers have been known to use things like webcam access. Programs can be used so employers can monitor employees when working from home. This is extremely invasive, and so employers should consider whether this is the most proportionate response for monitoring employees before implementing it. Similarly, keystroke logging can be used to monitor words that employees are typing, which also carries the issues of inadvertent data collection that you aren't expecting to receive or process. Employee monitoring is a hot topic at the moment, while the world's workforces are, where possible, working from home. Employers may be thinking of increasing these styles of employee monitoring in order to check up on employees. Some means are more invasive and some are less effective than others. It is important that employers weigh up the different approaches and alternatives and choose the most proportionate response to monitoring employees, which we'll go into more detail about later. For example, monitoring an employee through their webcam to check that they are working is unlikely to be the most proportionate response. A more appropriate method may be instead to check in on a more informal basis by calling to ask employees how they are and what work they've been working on. There are four main legal and regulatory pillars making up the framework around employee monitoring in the UK. The first is Article 8 of the European Convention on Human Rights. This protects the right to an individual's private and family life and correspondence. This can be enforced against public authorities under the Human Rights Act 1998, and breach of my right to privacy is the predominant head of claim pursued by individuals when it comes to employee monitoring and how they understand their rights have been breached. The GDPR and the Data Protection Act 2018 means that the processing of data collected in employee monitoring must be done so lawfully, transparently, and fairly. Monitoring in the UK must also comply with the Investigatory Powers Act 2016 and the Investigatory Powers, Interception by Businesses, etc. for Monitoring and Record-Keeping Purposes Regulations 2018. These acts essentially govern when data can be intercepted by businesses and how that material can be used. Employers must also consider local laws. For example, in the UK, the implied duty of trust and confidence into employment contracts is also relevant. Excessive monitoring can form the basis of a claim for constructive unfair dismissal, and excessive targeting can also prejudice fairness in a dismissal, for example, in disciplinary procedures, or form the basis of discrimination cases. This may differ compared with other European jurisdictions. The focus of the rest of the session is on the data protection obligations and principles, but compliance with these key principles often goes a long way to discharging obligations in connection with other legal requirements. And now, over to David, who'll be taking you through the key principles and trap.
Thank you, Rachel. Before getting on to the key principles, it's important to satisfy yourself that there is no means of achieving your desired aim without undertaking any monitoring. Good examples include training on how employees should respond to an attempted phishing attack. This might be a suitable alternative to monitoring high-risk employees' mailboxes, for example, but achieve the same aim, i.e. a reduction in data breaches. Another topical example could be to have buddy systems to create informal relationships. This can give people a platform to discuss issues and pressures, and might again reduce the insider threat posed by overtired employees uncritically clicking links which seem legitimate. On to those key principles. Whilst of course we would never suggest that there is a hierarchy of principles, when it comes to employee monitoring, some are undoubtedly more equal than others. Those are TRAP: transparency, reasons, accountability, and proportionality. Okay, we've cheated a little on reasons, covering purposes and lawful bases. Careful consideration and application of these is a must before implementing any monitoring solutions. Happily, that will also help you to demonstrate compliance with those other legal obligations Rachel has mentioned. I'm now going to touch briefly on each of the key principles. The first key principle is transparency. You must be able to demonstrate that employees were made aware of how you're monitoring them, what data you're collecting about them, and how and why you might use it. Generally, employers will have staff privacy notices which may refer to the principle that employers might, for instance, monitor their usage of employer devices. But it's important to go beyond that. The information needs to be accessible, clear, and easy to understand. It's sensible to ensure information is provided in a number of accessible policies, including the staff notice and, for example, an acceptable use of systems policy, bring your own device policy, remote working policy, CCTV policy, social media policy, and even disciplinary policies. These policies and the employer's approach to employee monitoring should be updated, circulated, and explained, for example on webinar or roundtable training, often. A word of caution. Frequently, where an employer is successfully challenged in respect of employee monitoring, including in high-profile actions in the European Court of Justice, it's because they fail to be clear about what monitoring solutions they use and why. On to reasons. As I said, this is a bit of a cheat because it encompasses two principles or requirements: purposes and lawful bases. Although it seems straightforward, you should ensure that you've clearly thought about and communicated the reasons why you want to take steps to monitor employees, or your purposes. This becomes the key benchmark against which proportionality will be measured, so it's sensible to ensure that your purposes are not immediately obviously flimsy. For instance, intrusive keystroke logging and webcam image capture to monitor time spent at home desks will hopefully strike all of our audience as an intrinsically bad idea. Of course, you also need to identify an appropriate lawful basis for processing of personal data in connection with monitoring activities. We have covered bases, or grounds, in an earlier webinar. Often the basis will be the employer's legitimate interests. Don't forget that those need to be weighed against the individual's rights and freedoms. Accountability is next. Avid listeners to this series will know by now that you will be expected to demonstrate and evidence the steps you've taken to consider and apply the principles and your obligations under the GDPR. More generally, it never hurts to have a contemporaneous record of any decision-making process, particularly relating to a sensitive topic like monitoring, where there's a very real prospect that those decisions could be subjected to judicial or regulatory scrutiny. The starting point, therefore, is that you should carry out and regularly update data protection impact assessments relating to employee monitoring solutions and activities. That should by no means be the end of your accountability journey, but I don't want to spoil the surprises in store in our final session of Module 2B. Do stay tuned. Finally, but probably most importantly, you must ensure proportionality in any employee monitoring activities. Often, a thorough proportionality analysis should be undertaken both in respect of whether or not to deploy a particular monitoring tool and how to configure it. That must involve a close examination of the employer's purposes on the one hand, and the impact of the proposal on the employee's rights and freedoms on the other, together with a thorough analysis of whether some other less invasive step might achieve the same aim. To take a basic example, it may not be proportionate to conduct a manual review of an employee's emails if the purpose of doing so is to prove a relatively minor allegation of misconduct, especially where it might be possible to speak to witnesses to the alleged conduct instead. Where it is proportionate to manually review mailbox data, for instance, to categorically prove or disprove an allegation of fraud, it will rarely be proportionate to trawl the entire contents of the mailbox. Instead, a limited category of emails identified by targeted searching may be reviewed by a single reviewer who's instructed to disregard emails marked private and who's committed to keeping the contents confidential. Two golden rules that apply to many monitoring tools and which are a good starting point for proportionality analyses are: first, where possible, block, don't review. For instance, creating a blacklist of prohibited websites and applications rather than capturing and then reviewing browser logs after the event. Secondly, automated processes are often preferable to manual monitoring requiring human input. Data loss prevention tools and email scanners always beat an information security manager reviewing a download and access log. It would be remiss of us not to remind you to consider and apply the other principles too, of course, including data minimization, the closely linked retention and deletion. You shouldn't collect and keep more data than you need. For some monitoring, which is carried out purely for physical and information security purposes, data can be anonymized or deleted almost immediately. Data protection by design and default. Are you selecting and installing monitoring tools designed with data protection in mind? For instance, does your CCTV system allow easy searching and blurring of third parties to support disclosure of footage in response to DSORs? Purpose limitation. If you implement CCTV for security purposes, it won't generally be appropriate to use it in formal performance management processes, for instance. Accuracy. It can be tricky to ensure that physical or systems access log relates to the tagged employee when they could have lent their pass or login credentials to a colleague, for example. And of course, security. Ensuring records of monitoring are locked down is of paramount importance, given the sensitive content of much of them. We wanted to finish with some further practical tips and suggestions. Firstly, understand the scope of your monitoring tools and current usage. A monitoring audit can be helpful. In our experience, it will often identify practices that privacy professionals are not aware of, and can also result in you catching monitoring functionality which has been built in and switched on in respect of day-to-day employee platforms like CRM systems. Assess new products and acquired businesses. Ensure each new product, platform, and acquired business is or are assessed, and proper diligence is carried out on their capabilities. Ensure policy alignment. It's important to ensure your policy suite is aligned, clear about monitoring activities, and clear about when the results of monitoring may be used. That will typically involve checking those policies mentioned at the outset, AUPs, notices, etc., but also, for example, global investigations policies and procedures, and whistleblowing policies too. Hopefully by now you'll feel better equipped to understand the typical types of employee monitoring, understand the regulatory and legal framework for employee monitoring, and apply the most important principles when carrying out employee monitoring.
Thank you for joining us for today's session on employee monitoring. You can reach either me or David on the contact details shown on the slide if you have any further questions about employee monitoring. And as mentioned, the other recordings are available on the Fieldfisher YouTube channel.